Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Caboolture Magistrates Court. Client was charged with drug driving. There's two forms of drug driving. The more serious is driving under the influence of drugs, meaning you're high on drugs. That wasn't the case today. And the lesser charge, which is what my client was actually charged with, is what's called driving whilst a relevant drug is present, which simply means that you've consumed it at some point. There's traces of it still in your system, but you're not actually high or under the influence of it. My client was found to have ice or methamphetamine in his system. Basically, he'd had a few beers with some friends, unquote, the day prior. There was people consuming drugs. It was offered to him. He didn't want it. Stuck to his beer, and then the next day was found to have it in his system. So obviously someone slipped it to him in a beer. In any event, he was driving for work purposes at the time, so he wasn't able for that reason to apply for a work licence. To be able to apply for a either a DUI drink driving work licence or a drug driving work licence, basically there's a number of prerequisites. One of them is that you can't have been driving for work purposes when intercepted. The legislation's pretty black and white on that, but I've sort of gathered case law over the years which has allowed me to persuade magistrates to distinguish between actually driving to do your job and driving to and from work. So the case law is all over the shop, but again, if you're driving to and from work, I am generally able to persuade a magistrate that that's not actually work purposes. But if you're doing your job, so let's say you're driving a cement truck and you're driving out of a large cement provider complex after having filled up, clearly you're driving for work purposes. Whereas if you were driving to the depot from home to start work, as I said, I am able to persuade magistrates that that's not work purposes for the sake of applying for a work licence. And as I said, if I'm able to persuade the magistrate of that, that will make you eligible to apply. But the client was not in that situation. He was in a situation where he was actually on the job, and it was impossible to suggest that it was anything other than being in the process of earning a living as opposed to driving to and from work. So for that reason, he wasn't able to apply for a work licence. So my job was one of getting the disqualification down as low as possible. Worst case scenario for first time relevant drug present or low range drug driving offending is a 9-month disqualification. So worst case today was 9 months. Mandatory minimum, meaning the best case scenario is a 1-month disqualification. So as I said, because he wasn't eligible to apply for a work licence, my job was one of trying to get it down as low as possible. And as I said, the lowest possible is 1 month. He also had concerns with regard to the recording of a conviction for a number of reasons that I won't go into now. So as I said, my job was twofold: A, trying to get the disqualification down as low as possible, and B, doing my best to try to persuade the magistrate not to record a conviction. I had my client complete the reformatory course that we get all of our clients to do. I drafted an affidavit for him to sign talking about what he'd learnt, got him to get references based on the template that we give all of our clients. Once I had the form that I'd also sent him requesting him to give me his life story, you know, him as a person, family situation, difficulties he suffer while he's off the road, what happened on the day in question, etc. Once I had that and the police brief, then I was able to draft my submissions. I met the client today at court, ran through everything with him before we went in, and made my submissions to the magistrate. So there was a number of key points that I addressed in trying to convince the magistrate that my client should be treated to anyone else who may be in this situation. Again, I'm not going to go into those points now, but I took the client on a journey, you know, my client's life, where he's been up till now, how he ended up in this situation, and why the magistrate would be appropriate in considering him to have done this as something that's out of character, and he won't expect to see my client before the courts again anytime soon, if at all. With regard to the recording of a conviction, I referred to the various sections of the legislation and alluded to case law. The short version is I was successful on both fronts. The magistrate gave my client the mandatory minimum 1 month disqualification, so he's off the road for 1 month only. And I was also successful in persuading the magistrate not to record a conviction. So 1 month disqualification, modest fine, no conviction recorded. Client's very happy. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road. Does your license need saving?